My name is Adam Himes. I'm a partner in Kuits commercial property team, and welcome to Kuits commercial property webinar September 2024. Next slide, please. There will be four short speeches and discussions here. Firstly, Matt Grelier, who's a partner and head of our construction team, will be speaking about risk management and dispute management in the context of construction law. Charlotte Barker, who's a senior associate in our department, will be talking about leases, repair and maintenance aspects from landlord and tenant perspectives. Sally Knight, who's also a partner in our department, will be talking about service charge in the context of leases. And finally, I'll be talking about planning changes in the light of the new government that we have, relatively new government that we have. So, as I say, to start off, I'm going to hand over to Matt Grelier, who will lead the first piece. Thank you.
Thanks, Adam. Good morning, everyone. So during this part of the session, I'll provide some practical tips for construction contract risk management during the following phases of a construction project: procurement, contract formation, and contract administration during the life of the construction phase. Taking procurement then, there are different routes by which the design and construction of a project can be procured, including, for example, traditional procurement, design and build, known as D&B procurement, management contracting, or construction management, for example. But the two main procurement routes, the most popular routes, are traditional procurement and design and build. And these can be summarized as traditional procurement being a process where the design is separate from construction, and the documentation, like the contract drawings, bills of quantities, and so on, they're supplied by the client before the contractor tenders. And responsibility for design, that rests with the client and their consultants, whereas responsibility for construction rests with the contractor. Whereas design and build, that works on the basis that the main contractor is responsible for undertaking both design and construction work. So there's more of a single point of responsibility for design with the contractor. And there are various factors that are going to determine the appropriate procurement route, including the client's objectives, their appetite for risk, including in relation to where design risk responsibility falls, the speed of delivery for the scheme, cost, quality. And it's recommended that early advice is taken as to the pros and cons of the different procurement routes and the appropriate form of construction contract to use. That's going to inform whether there's an industry standard form of contract published by, say, the JCT or NEC that's appropriate for the project, or whether an entirely bespoke contract is needed. If a standard form of contract is chosen, consider then whether amendments to that standard form of contract are required. Schedules of amendments, so documents which are usually appended to the contract, which amend the standard form terms, they've become common industry practice. They reflect the bargaining position. Usually they're used to make the contract more onerous on the contractor, to allocate risk to better protect the client, and also to deal with the project-specific risk. For example, is adverse ground or site conditions something that needs to be catered for, or are we dealing with a higher risk building, and we need to consider the additional duties and requirements as regards recent building safety legislation. Schedules amendments are also used because they're often expected by and needed to cater for the requirements of interested third parties to the project. So future tenants, funders, future purchasers. And that's an important consideration for a developer client during that procurement phase, is to consider the obligations that they're under third-party agreements, for example, agreements for lease, or facility agreements, funding agreements, and to consider whether any of the obligations in those agreements need to be covered off within the terms of the building contract. For example, does the funder require the benefit of a collateral warranty from the contractor and their subcontractors in a particular form? Do they expect the contractor to effect and maintain a particular level of professional indemnity insurance? If so, it's really important to establish what those requirements are and make sure they're stepped down and catered for in the building contract. If a standard schedule of amendments is required, then exercise caution when amending, and importantly, include the schedule of amendments in the tender pack that's going out to the prospective contractors. Don't move the goalposts for the contractor. I've seen it before where a developer client's identified, they've gone through the tender process, identified a contractor, and then after the event they're looking to impose a more onerous set of amendments to the standard form contract, and understandably the contractor's not very happy about that and wants to perhaps reconsider their price, for example, because they've seen a shift in the risk allocation. Also ensure that you're getting advice from appropriately qualified professionals. Which specialists are required for this project? Has a principal designer for the purposes of the construction design management regulations, the CDM regulations, and for the purposes of building regulations been appointed? And is the individual sufficiently competent to perform that role? Is a quantity surveyor needed, a project manager? As a developer client, you want to ensure that you're getting the appropriate advice during that procurement phase. Leading up then to entering into the building contract, it's crucial to undertake a detailed legal and technical audit of the documents that make up the contract. That's including the technical documents like the specification, the employer's requirements, the contractor's proposals. These documents, they are fundamental to the operation of the contract. And it's important to try and identify any ambiguities or inconsistencies that there might be in or between those documents, and then address them prior to signature of the contract. And before putting pen to paper and signing the contract, check that the final set of contract documents, check that final set of contract documents before execution. Are the agreed latest versions of those crucial technical documents, for example, the employer's requirements, contractor's proposals, are they properly appended and incorporated into the contract? And crucial bit of advice: execute the agreed contract, sign the agreed contract before works commencement. Parties are going to be proceeding at significant risk if they're on site clashing on with the work without an appropriate contract in place. Moving then to contract administration and dispute avoidance during the life of the construction phase. Headline point is, don't put the contract in a drawer and forget about it. Following the contract is crucial, and it doesn't need to be adversarial. The contract is there to provide a roadmap. So often I've heard it from both developer clients and contractor clients that they are worried about coming across as adversarial or too contractual. But both parties signed up to that contract, and of course it's all about how you go about it, and maintaining appropriate dialogue and collaboration. I'll run through some points now which they might seem like common, a lot of it's sort of common sense, but I think they're worth very, very much keeping at the forefront of one's mind when in that construction phase. Firstly, ensure that there's an effective handover from the procurement team to the project delivery team, and ensure that the key personnel within your business understand their roles and their responsibilities regarding the construction contract. It's then important to understand and apply the contract provisions on time and correctly. For example, there can be very grave consequences for an employer client, for example, that fails to properly follow the payment provisions under a construction contract as regards the giving of payment notices and pay less notices in circumstances where they want to pay less than the sum that's been applied for by the contractor. Crucial to follow the notice, information, communication requirements strictly. If the contract says send that notice with a pink ribbon on it by horse and cart, then do that. In dispute scenarios, parties often take very technical arguments around the method of service and the form and the content of notices. Maintain records and an organised paper trail. That becomes crucial in the event of a dispute. A party that's got their house in order, good document management, they're going to find themselves organised and perhaps on the front foot in the event of a dispute. And finally then, seek internal support from colleagues and legal advice as and when appropriate. And that brings my part of the session to a close. I'm going to hand over now to Charlotte Barker, who's going to cover lease repair and maintenance issues.
Thanks very much, Matt. Morning, everybody. So I'm going to be talking about leases, focusing on the repair and maintenance obligations from both a landlord and tenant. When we talk about repairing a lease, the extent of a landlord and tenant's responsibilities depend on the nature of the lease. When referring to a lease of whole, the term full repairing lease indicates that the tenant has full responsibility for the repair of the whole of the property. The tenant will normally be directly responsible for carrying out the repairs and will bear the cost of doing so. If the demised premises form part of a larger property, a full repairing lease, while this also places direct responsibility on the tenant for repairing the demised premises, it also makes the tenant indirectly responsible for the cost, or at least a proportion of the cost, of the repairs to the structure, exterior, and common parts of the property through a service charge. Thinking to begin with about repair and maintenance from a landlord perspective and the obligations that a landlord may find itself in. I want to talk specifically about a recent case of London Borough of Tower Hamlets versus the lessees of the Brewster House and Malting House, which was a 2024 case relating to service charge disputes. The case analyses whether major expenditure on a building fell within the service charge provisions of a lease. It highlighted the idea that an obligation to maintain does not create an obligation to make a building safe, and the general words of a sweeper clause would not extend to such a major commitment. The brief facts of the case for those not familiar. The tenants of Tower Hamlets LBC had acquired long leases pursuant to the rights to buy, rights to lease provisions of the 1980 Housing Act. The buildings in which the flats were located were revealed to have safety defects, such that the works were costly, and the landlord sought to recover part of the cost from the lessees in the buildings via the service charge. The lessees contested the attempt at recovery on the basis that the works did not fall within the service charge provisions of their leases. Under the leases, the landlord was entitled to recover costs in complying with a covenant to A, maintain and keep in good and substantial repair and condition the main structure, and also B, as a form of sweeper clause, a covenant to do or cause to be done all such works, installations, acts, matters and things as in the absolute discretion of the lessors, may be considered necessary or advisable for the proper management, maintenance, safety, amenity, or administration of the building. The works were required to remedy a safety defect. The parties were in agreement that the works did not involve repair, as there was no current damage or deterioration in the physical condition requiring repair. However, the question was, could the works be described as works to maintain the building? The judge in the case felt that whilst a covenant to maintain meant something different from a covenant to repair, denoting something preventative rather than remedial, neither covenant was a covenant to remedy structural defects or to make a building safe. Whilst maintaining involved an element of preserving the condition of the property, to preserve is not to make something new or to make something safe that was not already safe. Recovery of costs was therefore not within this aspect of the service charge. As for the sweeper, the judge felt that since the repair and maintenance obligations of the leases did not expressly extend to the not have been the case that such expenditure could be tucked into the general words of a sweeper clause. The sweeper, it was felt, was designed to provide for items not yet thought of, but if the landlord of the costs of items vastly different in kind and scale from those expressly specified, clear words would have to have been used. It was also noted that the remedying of structural safety issues tended to be very expensive, and such expense was not something one would expect to be covered by general words alone. Whilst in this specific case, the impact on Tower Hamlets has been hugely costly, it arguably has wider significance for landlords of other buildings and for defects which are only just being discovered or yet to be discovered. The case clearly has potential broad significance. If works to remedy structural defects or arguably other safety works do not fall under a covenant to repair and maintain, and there are no such works, then A, the cost of such works will not be payable, but also the carrying out of such works would not be an obligation of the landlords such that the leaseholders could enforce it, though bear in mind that there may well be other clauses within the lease that could compel the landlord to do such works. Had the covenant been to repair, maintain and improve, this may well have covered remedying structural or other safety defects, or if the building has been subject to enforcement by the local authority or fire service and there is a comply with notices or order by a public body clause in the lease, that might well cover it. The principle that safety works are not maintenance per se is certain to see further application and discussion. Now I want to move on to talk a little bit about repair from a tenant's perspective, where the obligation is on the tenant. A tenant will usually covenant to keep the premises in repair. A covenant to keep the property in repair includes an obligation to put the property into repair if it is in disrepair at the start of the lease. The rationale for this is that if the tenant covenants to keep the property in repair, then it must first put the property in repair to enable it to perform the covenant. It's making the lease, the tenant inspects the property and the building of which it forms part for disrepair and then assess the potential repair costs, either to be borne directly by the tenant or indirectly through a service charge. Many leases require the tenant to keep the demised premises in good repair, good and tenantable repair, or substantial repair. It is uncertain whether the additional words actually add anything to the obligation to repair, and there is case law to suggest that generally they do not. However, the construction of the repairing covenant will depend upon the specific facts. The age, character, and locality of the particular property are relevant to the standard of repair needed under a covenant to keep it in good tenantable repair. A tenant should consider restricting its obligations to simply keeping the property in repair to avoid assuming a more onerous standard. A covenant that requires a tenant to keep the property in good repair and condition is more onerous than one that specifies good repair alone. Reference to condition could require works to be carried out even if there is no disrepair. The state of repair of a property can cause disputes at the end of a term, when the tenant must return or yield up the property to the landlord. Problems may also arise if the lease is a business lease and the tenant would like to renew under the 1954 Act, because if the property was in disrepair, the landlord may be able to oppose the grant of a renewal lease. The standard and nature of the work that the tenant must carry out depends upon the age and nature of the property at the date of the grant of the lease. So if the property is an old building, a covenant to repair it will not require the tenant to modernise it. A duty to repair does not equate to a duty to make it safe. The danger with making a tenant repairing covenant too onerous is that it could be disadvantageous to a landlord at rent review. To prevent ambiguity or onerous requirements, a tenant may wish to limit its repairing obligation to keeping the premises in the same state as they were in at the grant of the lease. This is particularly so when the premises are in a poor state of repair, as a covenant to repair would require the tenant to put the premises into repair first. If the parties agree to limit the tenant's repairing obligation in this way, they should prepare a schedule of condition to show the state of the premises as at the date of the grant of the lease. The schedule should include photographs and ideally a detailed description of the condition of the property, and should be signed by both parties and annexed to the lease, and this will serve as a reference. If a tenant is taking a lease of relatively newly constructed premises, it may wish to consider carving out liability for disrepair caused by inherent defects and remedying the inherent defect itself. In short, an inherent defect is any defect in the premises or anything installed in or on the premises which is attributable to defective design, workmanship, materials, or defective supervision of the construction or installation of anything in or on the premises. For example, an inherent defect in a roof which may give rise to water ingress causing damp. Whilst the tenant would not be required to remedy the defect under the repairing covenant if the inherent defect does not cause the damage, if the inherent defect does cause damage to the property, the tenant will be required to repair the damage. Compliance with a covenant to repair may require remedying the inherent defect in certain circumstances, for example, where this is the only means of effecting a repair of the property. A tenant should be cautious and clarify the precise extent of its repairing obligations when taking a lease. For both landlords and tenants, it is important where they seek to exclude or limit liability for certain repairing aspects, that they ensure that there is an obligation on the other party to repair and contribute. If a property is newly built, it should be considered who has the benefit of any warranties from the contractor and professional team when considering clauses in a lease. What can on the face of it appear a very simple clause in a lease, repair, whether an obligation on the landlord or the tenant, can, depending upon how drafted, open up a whole area of debate and argument, especially where the drafting isn't clear. Consideration is given to the nature of the property, the circumstances, and the bargaining power between the parties. Here at Kuits, we can provide clear, practical, and appropriate advice on the complex issues that can arise in respect of repair from both the landlord and tenant perspective, to ensure that suitable drafting is in place with consideration given to the interplay between different lease clauses. Thanks very much for listening. I'm now handing over to Sally, who's going to be talking about service charge recovery.
Thanks, Charlotte. So I'm going to cover a case regarding some service charge recovery of litigation costs, professional costs particularly, and it does follow on from some of the points that Charlotte was talking about in terms of sweeper clauses and catch-all clauses within service charge provisions. So as you'll be aware, service charge provisions usually are meant to cover maintenance and repair of, for example, the structure of a building where you have a number of tenants who have internal only demises. One of the reasons that we have a sweeper clause is because it can be really difficult to anticipate all of the specific items which might be necessary to be undertaken and costs which may be incurred in providing those services. So you will usually see some kind of sweeper provision which allows a landlord to undertake services which it considers reasonably necessary, and we're not listed in the express list of services, and to also recover costs which may not fall within one of the express lists of costs which everybody has foreseen. Now, this particular case of Holland Park Management Limited against Mr. and Mrs. Dell was heard in the Court of Appeal in December last year and looked really closely at particular sweeper clauses and what those sweeper clauses could be construed to allow recovery of. Now, in this instance, there was a freehold owner of a significant residential property in London, and they were looking to recover around £430,000 worth of litigation costs from one of the residential tenants. This was a proportion of a total of £2.7 million worth of litigation costs, which had been incurred. Now, those costs related to two forms of litigation. Firstly, there was a case with the neighbour who owned some property next door and wanted to develop that property. Now, the building had a restrictive covenant, and the building owner could prohibit development of the neighbouring property where it was reasonable to do so. So the neighbour had applied for consent to develop the adjoining property, and the building owner refused that consent and felt that it had done so reasonably. The neighbour challenged that in court and said that the consent had been unreasonably withheld. The tenants within the building all agreed that the freeholder should defend that action and try to uphold the refusal. So a significant proportion of the litigation costs were incurred in relation to that case. And then the freeholder had also taken action to oppose the planning application submitted by the adjoining neighbour. Now, it's important to note that at one point, whilst the tenants had all been in agreement that these cases should be taken forward by the freeholder, Mr. and Mrs. Dell did withdraw their support at one point and suggest that the litigation costs were excessive and were not outweighing the benefit that could be found from winning either of those cases. They then brought a case forward suggesting that the recovery of these litigation costs was not valid under the terms of the lease. Now, in this instance, the particular litigation costs were not listed expressly within the terms of the service charge provisions. So it was necessary for the court to take a look at the sweeper clauses within the lease. And on the next slide, I've just listed the various sweeper clauses that the court had to consider. So firstly, the landlord could employ various listed professionals as may be necessary or desirable for the proper maintenance, safety, and administration of the building. And it's those words there, maintenance, safety, and administration, which were the key terms in this instance. So the second sweeper clause that you can see there talks about the landlord being able to carry out any works or undertake any things which were reasonably required, again, for the proper maintenance, safety, amenity, and administration of the building. So the court had to look at these terms, management and maintenance, and what it held that it was too much to suggest that these sweeper clauses could cover this type of litigation cost. Whilst the litigation would prohibit the development of the neighbouring premises, the court didn't feel that that sufficiently fell within the maintenance or safety or administration of the building. The court said that the relevant clauses were clearly intended to fund the landlord's obligations as a landlord maintaining the building, rather than to support its wider interest as a freeholder of the property. So the court looked more widely at how were litigation costs dealt with within the service charge clause more generally. Now, some specific litigation costs were expressly covered, and the court felt that this indicated that if other litigation costs were not expressly listed, then they were effectively intentionally omitted. If the costs were intended to be recovered, they would and should have been listed as recoverable costs. Now, in this instance, the court noted that it was particularly relevant that there had been a history of litigation with the neighbour in relation to development of the neighbouring property. And in fact, that dispute predated the terms of this particular lease. So the court held that it was clearly foreseeable that further disputes could occur, and that because the freeholder had notice of that potential dispute, if it had intended to cover those litigation costs, it would have expressly listed them. So the landlord appealed and asked the court to look at one further sweeper clause, which you can see there on the slide. Any other costs and expenses reasonably and properly incurred in connection with the building. Now, in this instance, the court again supported the original decision and found that this wording was again too narrow to cover this type of litigation. It said that the reason that costs were, so one of the reasons that it stated was that the expenditure must relate to the building itself, rather than anything else, such as adjacent land. The court stated that it was inherently unlikely that the parties would have intended to include an obligation to fund uncertain and potentially significant costs of a dispute with a neighbour within general wording in a definition, particularly in these circumstances where an extensive and specific provision had been made for other types of costs within the service charge. Now, the landlord is appealing this decision. And interestingly, if you look at the facts of the case that it defended in relation to withholding consent for development with the neighbour, the court in that instance found that the freeholder had actually validly withheld its consent to development, and that it had done so on the grounds of safety of the property. So it's interesting that in one instance they were held to have validly withheld consent on safety grounds, but in the service charge recovery case, the court felt that notwithstanding the reference to safety within the service charge sweeper clause, that the issue of safety wasn't proximate enough to allow the recovery of these litigation costs. Now, you may be asking yourself, why were the costs still payable by the freeholder if they won the restrictive covenant case? Well, in that instance, the neighbour was held to be liable for some of the costs, but not the entirety of them. And so the freeholder was still left with a significant bill. So what can we conclude from the results of this case? Well, it serves as a warning that sweeper clauses will not always come to a landlord's defence, where a landlord is trying to recover costs which have not been expressly provided for. It's really important to consider at the outset the nature of the building, the history of the building, and whether any additional unusual express costs should be specifically listed, rather than just relying on a usual form of precedent that a landlord may use. It's really important for investors to take a look at the current service charge situation that they are inheriting. So, have large sums been incurred during this particular service charge year, which you as an investor may be looking to have to recover following completion of a purchase? If you are putting in place a lease and looking to dispose of that property at some point in the future, are any of your purchasers going to have concerns about ongoing service charge recovery issues where you are looking to rely on sweeper clauses and catch-all provisions? Now, in this instance, the court emphasised that its decision turned on the specific facts and the specific wording of these particular sweeper clauses. The court wasn't required to give an opinion on what other costs could potentially have been recovered under these sweeper provisions. It was just necessary for it to consider, were these particular litigation costs recoverable? The court did, however, reference the extraordinary level of costs in this particular case, and it talked about the potentially ruinous level of costs which would have applied in this instance. They referenced the property potentially being completely unmarketable for the tenants if they were left with that level of a bill. So top tip would always be, if you are looking to incur a cost which is not specifically stated, or if you are looking to incur particularly high costs in any one service charge year and undertake significant works or significant professional fees, then always take legal advice before doing so. So that's everything around this case, which I hope you found helpful. I'm just going to now hand over to Adam, who's going to give you a quick run through of the current planning position. Thanks.
Yes, thank you very much, Sally, and also thanks to Matt and Charlotte for the previous talks there. So I'm going to talk about planning, and firstly, I should say this is going to be very much a whistle-stop, very general, high-level talk. I'm not going to go into great detail about many points, but just rather cover it on a high level. And I should thank a former colleague of mine for helping prepare these notes, which I'm going to be working from. So I'll see if I can operate the slides here myself. You see, yes. Okay, so to kick off, as everyone will know, we obviously have a new Labour government here. There's been a lot of talk about the existing planning system being not fit for purpose, words such as antiquated, a graveyard of economic ambition, and so on being bandied about. And the government has stated a mission to kickstart economic growth, which is all well and good, but what does that actually mean in the context of planning and property? So there's some immediate changes have taken effect, including the lifting of a wind farm ban, as referenced there, and more usefully perhaps for those of us who deal with these matters, more resources for local planning authorities to employ additional planning officers. It's been a long-standing problem with understaffing, I think, accepted across the piece in local authorities. So a revised NPPF, which is obviously the National Planning Policy Framework, is in hand, published for consultation. Just a few dates and facts here. Published for consultation on the 30th of July, as stated. Consultation stated to be running till the 24th of September, so very soon, obviously. And consultation's been extended more widely than just changes to the NPPF, and referencing their three pillars of change and importance: stability, investment, and reform. The view is that in the main, the NPPF is ultimately largely unchanged as it is, and the consultation has been referred to as just tweaking around the edges, unfortunately, but we shall see. Okay, housing. This is obviously a very pertinent point, much spoken of in the news and more generally in terms of planning, probably what the man in the street thinks about when talk of redevelopment and green belts and so on is in play. So very big point here. There's a return to a mandatory housing targets for local authorities. And of course, the initial reaction from the house building and property industry is that that's very much welcomed. Change to the way in which that's calculated, and a profound impact given that the target set is 370,000 new homes per year, which I think I'm right in saying has not been met for many years, even with the targets that have previously been had. So there's a lot of ground to make up. There's a change of the methodology for identifying what's classed as local need for housing. And for example, the government has published a spreadsheet on how proposed changes will impact specific local authorities. And as an example, there's a reference there to the draft NPPF talking about better reflecting the growth and ambitions across the Midlands and the North. So local plans, obviously highly relevant in terms of development. So there are transitional arrangements set out in Annex 1, and the revised NPPF will apply to all local plans 1 month after their publication, essentially subject only to certain exceptions, so they're going to bite straight away. And if local plans have been submitted no more than 1 month after the revised NPPF, and if the relevant local authority is more than 200 dwellings down on the housing need figure, then that local authority will need to commence a new plan at, quotes, the earliest opportunity, whatever that may mean, but clearly there's a bit of a stick there on local authorities. And similarly, but conversely, I should say, the deadline for submission of plans has been pushed back to December 2026, which is perhaps reflective of the realities of producing plans as required. And just a note that after December 2023, all local plans must be prepared in accordance with LURA, which is the Levelling Up and Regeneration Act of the government. Okay, so Greenbelt, a very hot topic within a topic, if you like, especially for the man in the street, if you will. Politically dynamite, you might say, in terms of how Greenbelt is affected by development. So just a quick bit of background, not on the slide there, but it's worth bearing in mind that we have 16,384 square kilometres of Greenbelt in this country, which is over 6,000 square miles. And interestingly, that over the last few years, the Greenbelt has been increased, in fact, by, albeit only 8.6 square kilometres, due to local authorities expanding and actually adding to the Greenbelt. It's also worth noting that 93% or thereabouts of Greenbelt remained undeveloped in 2022. That all being said, the NPPF now strengthens brownfield first approach. I'll come to that in a minute. Proposals for development in the brownfield should be regarded as acceptable in principle. There's a need on LPAs a need for LPAs to review Greenbelt policy where needs cannot be met. So it's that emphasis really shifting on meeting needs where they're there, rather than sort of imposing the Greenbelt restrictions. First and foremost, land must be allocated to meet needs in full, unless there is clear evidence that alterations would fundamentally undermine the function of the Greenbelt. So again, it's that emphasis in some ways, that a presumption in favour rather than a presumption against in some senses. Okay, grey belt is a term that's bandied about, and just, I don't have it on the slide, but the definition of the grey belt is land in the green belt that includes previously developed areas and those that contribute little to the green belt's purpose, but excluding certain significant environmental areas. So that's grey belt. And just to be clear, where land is to be released, the emphasis is on locations where it's sustainable, so that you go in order of previously developed land, followed by grey belt, followed by proper, you might say, green belt last of all. And just within that, housing, commercial and other development in the green belt, which is not released through the local plan, will no longer be considered inappropriate if it utilises the grey belt land, so we're talking about grey belt here, and it provides at least 50% affordable housing where it's residential development, if it makes improvements to the national infrastructure and provides new accessible green space. Interestingly, where the LPA cannot demonstrate a 5-year housing land supply, which is, I think it's fair to say, is the case for many, many local authorities, or delivery is below 75% of the housing requirement in the relevant authority, or that the land is demonstrably required for local, regional or nationally important development. So that's grey belt. And then again, just touching briefly, very briefly, on some other reforms, there's proposal to increase planning fees, including for householder applications, which may or may not be seen to be perhaps a bit penny pinching, but there we are, with possible increases for other applications and planning services as well. And there's also a possibility for local authorities to seek to recover NSIP, which is Nationally Significant Infrastructure Project related costs. Also in relation to NSIPs, increasing the scope of commercial projects which may be classed as such, and potentially raising the threshold for some renewable energy projects. The idea of strategic planning will be coming back, including in non-mayoral authority areas, so areas without a regional mayor. Climate change policy is likely to be strengthened, but the government wants ideas as to how, which is interesting, so consultation being key there, and also the idea of intervention into local plans, either removing or revising existing criteria. So in terms of reaction to the changes, just very generally, it's been welcomed by the industry, particularly house builder stakeholders. Delivery will require much needed resources, I should say, across all sectors and not just LPAs. So can't just rely on local authorities to wave the magic wand, as it were. Key point that has been mentioned for some time now, skills shortages in the construction industry. How will that be dealt with? Obviously, there's a wider social question there in terms of education, training and investment, and how to deal with the cost of delivering NSIPs, the National Significant Infrastructure Projects. Interestingly, I saw just, I think yesterday on the BBC News, a report which posited that the true cost of HS2, even the truncated section that we're now dealing with, could be closer to 80 billion plus rather than 50 billion plus, which itself was considered quite a high figure. So interesting to see that. So any other ideas? Obviously, the government has already consulted an open consultation with stakeholders, including major house builders. I'm personally aware of this. And there's talk of open doors and open dialogue, but I dare say that will all sort of remain to be seen. So, as I say, very much a whistle-stop tour, a whistle-stop tour, I beg your pardon, from me there, just highlighting some of the thoughts that arise out of the new government's proposals and approach to planning. But that really concludes my talk, which I hope has given some pause for thought. And we do have a little time, so we do have a few questions. I think just a couple of questions perhaps we might have time for. So one for myself, which is what steps might or should the government consider in terms of promoting new development? So what else could perhaps be in the mix? So just to light on a few points, I know from clients of mine that an ongoing problem for developers, house builders in particular, residential developers, are the demands of biodiversity net gain and nutrient neutrality, and these sort of environmental constraints, which, whilst perhaps understandable from an environmental perspective, do impose heavy burdens on developers and perhaps favour the larger developer who can deal with these costs and additional requirements. And just touching on that, maybe more help for the smaller developers. So I think it's on record that, you know, the number of smaller developers with developments of less than, say, 200, 250 houses has been decreasing over the years. Perhaps the government could consider some assistance for them. And again, just generally keeping eyes and ears open for dialogues with stakeholders, as I think I touched on in general terms. And I think just one more question, perhaps for Matt here. If Matt could give 3 key tips on the areas that he touched on for listeners, what would they be, Matt? If I could hand over to you, please. Thanks.
Yeah, sure. My top 3 tips across the 3 phases of a construction project. Then I think during that procurement phase, get early advice on the right form of contract and whether a schedule of amendments is required. Then leading up to contract signature, make sure that the technical documents, so like the employer's requirements and the contractor's proposals, they're reviewed properly by the right people that have got the expertise to do that. And then after contract signature, follow the contract. Don't just put it in a drawer and forget about it.
So thank you, Matt. Great advice, I'm sure. So we're finishing slightly early here, but we don't want to take up too much of your time and hopefully, impose too much on you. But I hope that all of those presentations have been interesting and useful for you. As I think Charlotte mentioned, obviously, we at Kuits are here to advise and help on any of these areas or any other area of property law, construction law, or indeed the wider field of law. So, as I say, I hope that was interesting and useful for you all, and I look forward to you joining on our next webinar. If you watch this space, that'll be coming soon. And thanks again, and see you all soon.